and our founders made it so in the executive branch with the separation of powers for a reason. So I'm going to proceed, and I'll just go through my slides. So initially, very few people understand the enormous power and authority that comes with the office of the sheriff. Sadly, a lot of sheriffs don't understand that either regarding their full scope of authority. But to put things into perspective and understand why their authority exists, you've got to start at the beginning of our nation and understanding its founding principles. So to properly understand the authority of the office of the sheriff, you must first understand the authority, and more importantly, the limitation of the authority, the federal government. So with that, the authority of the individual states, as well as the true source of government and authority in our nation. And only then does the authority of the office of the sheriff come into proper perspective. The history of the sheriff in the days of old England, when kings and nobles ruled and people were subjects, or basically chattel, property, the kings understood and the nobles who ruled understood the common law, the law of nature. That's the law in all parts, must be enforced and protected. So the sovereign would appoint a reeve over the shire to protect their subjects and enforce the common law and keep the king's peace. Eventually the reeve evolved into shire reeve and then became the sheriff. So this official was brought to the colonies in the Americas and still had the same function. And however, with the completion of the War of Independence, the Revolutionary War, and the ratification of our Constitution, which created three co-equal branches of government, the sheriff falling into the executive branch and being elected by the people within their political subdivision of the county. So he is the supreme peace officer tasked with enforcing the law, and that's common law. Today we operate under admiralty law or commerce law. So there's a video I've included in here. I'm going to go ahead and play it because I think it makes a statement that we're all feeling and that needs to be understood.
Colonized America, we won't stand for tyranny. Okay, and it's too late to apologize. It's too late. I said it's too late to apologize. It's too late. It's
So I included that in there because it strikes a chord emotionally with me, but there's a tenor across this country right now that we all feel. And citizens more and more are getting educated regarding their constitution, their natural rights. But the sheriffs are still the key because they are the guardians and the high protectors of the people's rights. They swore the same oaths as all elected officials, but many do not understand their authority. They think they take their cues from the judicial branch or the legislative, yes. If their decisions or their legislated law comports with the Constitution itself. But the first official document of the nation in its founding, which is still in effect, is the Declaration of Independence. And when you read it, we hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. And I'm not going to finish all of that, but the point is, this is our government. And they've forgotten that. And in that video, it shows the smugness of King George, which many elected officials today seem to have regarding how they view the public or the people. As a peace officer, I am to be a minister for good, protecting rights. But our declaration clearly states that power and authority emanates from the people to the government, not from government to the people. It is also specific that the people have the right to alter or abolish the government whenever the government becomes destructive of the rights of the people. Thomas Jefferson stated the Declaration of Independence is the declaratory charter of our rights and the rights of man, not Americans, but man, those natural rights. Alexander Hamilton stated, "Here, sir, the people govern." And this is what we have to remember. And our elected officials, they're not our adversary, but they need to be educated and reminded that they have limitations, not the people. Then the people had not only had the authority, they retained that, the people not only had the authority, they retained that authority over government if it does not stay within the boundaries set forth within the Constitution. So what is the Constitution? It is the form of government delineated by the mighty hand of people in which certain first principles of fundamental law are established. The Constitution is certain and fixed. It contains the permanent will of the people and is the supreme law of the land. It is paramount to the power of the legislature and can be revoked or altered by the authority that made it. William Patterson, and that's Van Horn's Lessee versus Dorrance, 1795, a court case. In another letter, Henry Lee, Thomas Jefferson, and this was the subject of the Declaration of Independence, not to find out new principles or new arguments, never before thought of, not merely to say things which had never been said before, but to place before mankind the common sense of the subject in terms so plain and firm as to command their assent and to justify ourselves in the independence we are compelled to take. And then in the Kentucky Resolution, in paragraph 8, 1798, in questions of powers, then let no more be heard of confidence in man, but bind him down from mischief, pains of the Constitution. The point is, what I'm trying to make with this is that we, the people, rule. This is our government. We have to be invested in it, but we must understand our own form of civil government. In our national constitution, it begins with the substantially oversized words as compared to the rest of the document, "we the people." It goes on to say, "of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote general welfare, and secure the blessings of liberty to ourselves and to our posterity, do ordain and establish this Constitution of the United States." 17 September 1787, but look at those words. Establish and secure the blessing of liberty. Most people don't understand what their liberty is anymore. They think the Constitution gives them their liberty or their rights, and that is not true. It only codifies it here on earth before men. After the Constitution had nearly been ratified, they wanted a Bill of Protections, a Bill of Rights, because they understood government would not stay within its limitations. And not all the states would sign it until they had a Bill of Protections. James Wilson was one of the signers of the Declaration of Independence and the Constitution. He's a member of the Pennsylvania Provincial Congress and a member of the Second Continental Congress. So after the ratification of the Constitution, which forms this republic's form of civil government, the states realized government would not stay within the chains. So they wanted that Bill of Rights. And people don't understand that the Bill of Rights is law. It is part of the Constitution itself. James Wilson's quote in Pennsylvania in 1787, where he states, "We have remarked that civil government is necessary to the perfection of society. We now remark that civil liberty is necessary to the perfection of civil government. Civil liberty is natural liberty itself, divested of only that part which, placed in the government, produces more good and happiness to the community than if it had remained in the individual. Hence it follows that civil liberty, while it resigns a part of natural liberty, retains the free and generous exercise of all the human faculties so far as is compatible with the public welfare." So what he's saying is our government is still limited, that citizens, individuals, are free to exercise their liberty, their right of conscience, their free speech, exercise of their labor. But government doesn't have authority over it. The Declaration of Independence established at the beginnings of the document that the authority government derives is from we the people. And the purpose of the Constitution and the government is for our well-being, safety, and liberty. The writers of the Constitution continue to enumerate the authority and limitations of authority of the three divisions of government in the order of importance by their placement based upon the doctrine of primacy. The first is the legislative, Congress. The second is the executive, being the president and vice president, and including the sheriff. And the last is the judiciary, meaning the Supreme Court and the lesser federal courts. In my state, in all states also have their own individual constitutions, which will nearly mirror the federal Constitution. And in most, their preambles usually will thank God directly, or the supreme ruler of the universe, or hand of providence. So particularly for Washington State, you're plugging in here, Article 1 is Declaration of Rights. Rights are inherent. They cannot be given nor taken away. Section 1 is political power. All political power is inherent in the people, and governments derive their just powers from the consent of the governed. And that's particularly today what government has gotten. that their just powers come from our consent, but are they doing the things we wish them to do? Continuing on, and are established to protect and maintain individual rights. This is my prime directive as a peace officer. This is the prime directive of any elected official. The portion where it says maintain reverts back to inherent. They're always there. They must be maintained. And then secondly, Section 2, Supreme Law of the Land. The Constitution of the United States is the supreme law of the land. If most of you will go back and read your state constitutions, you'll find much of this out. Oregon's state constitution nearly mirrors Washington's state constitution in the first several of their articles. So the authority of Congress and the federal government. The authority of Congress and the government at large is found in Article 1, Section 8, and it is very important to understand that what these are and the limitations that exist. And if you can see my PowerPoint, I'm just going to skim through these. But the Congress shall have the power to levy and collect taxes, duties, imposts, to pay debts, and provide for the common defense and general welfare of the United States. Federal government is to act outside the United States. They are limited to 10 square miles of the district. But all duties, imposts, and excises shall be uniform throughout the United States. So if that is in the Constitution, why do we have a graduated tax system? Just a question. But as you move through these, they have the power to coin money, regulate the value thereof. They've given that up. They've given it over to a private bank, the Fed. They have the power to declare war, grant letters of marque and reprisal. That's what private contractors were when I was in Iraq. They were working for them. To make rules for government and regulation of land and naval forces, the militia, and to make rules for calling forth the militia. I'm just going to skim through these, but I'm going to pause on Article 1, Section 8, Clause 17, because right now there is a lot of question over the western states that have not been disposed of. When you hear it, it's right there in the law, the Constitution, the limitations of the boundaries of the District of Columbia. It says to exercise exclusive legislation in all cases whatsoever over such district exceeding 10 square miles as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States. So their limitations are within 10 square miles of the District of Columbia, not without. States have sole authority over their lands, but they have not been disposed of. If anybody's been following the news, you're up to speed on that. The legislatures in each state can withdraw their consent to cession of lands. They don't realize that either. Continuing on, and exercise like authority over all places purchased by the consent of the legislature and the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful things. That's what can place military bases, ports, naval ports, and things within states, but they've got to get state permission for it. So the federal government is limited. The states have superior authority. So let's talk about the limitation of the federal government. That is the limitation of power that we, the people, loan to Congress. We have loaned our government our authority. We have ceded some of it to them. And upon its examination of the amendment, shows that there are primarily further limitations on the government and protections of the people. Any authority not specified in the Constitution does not exist. And we all have seen extrajudicial decisions and regulation by unelected bodies. They have forgotten their limitations, but the people have also forgotten that they loan their authority to them. So it's also important to note that Congress' primary authority is limited to international affairs, the District of Columbia, and federal lands. It's also important to note that while it is the Constitution for the United States of America, for the most part, in the text it refers to the United States, not the United States of America, thus implying the states united as opposed to a centralized federal government. So in reading the Federalist Papers and the debates on both the Declaration of Independence and the Constitution, it's clear that the Founding Fathers were most concerned with individual rights and states' rights. They did not want nor intend a strong central or federal government, as they equated that with the same type of tyrannical power wielded by the King of England and other sovereigns. This is the reason that so much authority was vested in the locally elected sheriff. Chief Justice Joseph Story, in his on the Constitution, stated, "Another not unimportant consideration is that the powers of the general government will be and must be principally employed upon external objects, such as war, peace, negotiations with foreign powers, and foreign commerce. In its internal operations, it can touch but few objects, except to introduce regulations beneficial to the commerce, intercourse, and other relations between the states, and to lay taxes for the common good. The powers of the states, on the other hand, extend to all objects which are, in the ordinary course of affairs, concern the lives and liberties and property of the people, and the internal order, improvement, and prosperity of the state." So when you look at these, it is still the states and the people that have inherent power. We are not subjects. We are not owned by our local or state or federal governments. We are individuals with individual rights. But we cede some of those so that they may be ministered for our good. Now the president, the office of the president, is similarly limited as defined in Article 2, Sections 2 and 3. Section 2 states, "The President shall be Commander-in-Chief of the Army and the Navy of the United States and of the militia of several states when called into actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have the power, with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur." Have we had treaties made without concurrence of our senators? I think we have. UN Arms Treaty. "And shall he nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors and other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States." But the point is, the president's authority is still limited by the Constitution. He may not act capriciously of his own. Congress has the sole authority. Section 3. shall from time to time give the Congress information of the State of the Union, right? The State of the Union address, and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses of either of them, and in the case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. Okay, those are his executive duties, but he doesn't get to make law by being capricious and arbitrary in his decision. He doesn't get to be a king. We, the people, also do not directly give our authority to the president, as he is not elected directly by the people, but by the Electoral College. This act also diminishes the power and the authority of the president, as he does not directly receive his authority from we, the people. Well, the Electoral College is a subject for another day, but at the federal level, that is reserved for the members of Congress who are supposed to represent us and act on our behalf. I think Congress approval rating is about 7 to 9% today. Other positions, such as the U.S. Attorney General, who have prosecutorial powers, are not elected by we the people and therefore have limited authority in addition to the general limitations of the office. So understand, the Constitution meant to limit the power of government. We were meant to live and have the liberty of free men, right of conscience, dominion over property, dominion to dispose of property. So much of the problem with government arises when the created believes it has equal or superior authority to the creator, we the people, behest, but they can also be removed at our behest, either through recall or at the end of their term, we elect another person to represent us, to be the executor of our laws, meaning they're written at the legislative level. They're still our laws. But police chiefs, officers not elected, are not true constitutional authority. They are appointed, however, by mayors, city councils, and are required to swear the same oath under Article 6, Section 3 of the Federal Constitution because they enforce the law. They have authority over you. They can stop you, detain you, even take your life. And that's why they still have to swear an oath to the Constitution. The problem is they work at the behest of their mayors and their city councils. Men are temptable, corruptible, and fallible. And many chiefs and the officers, if they don't do which their mayors and city councils require of them that may violate the law, meaning the Constitution or a person's rights, they be dismissed or replaced. And that is a difficulty in their decisions that they have to make. Do I protect rights, or do I listen to the mayor and the city councils and still receive a paycheck? But the sheriff is unique in being loaned this authority and trust directly by us, we the people. And therefore, he has a higher level of authority than any other member of the executive branch. And consequently, higher responsibility, authority, and accountability than any other government official. This gives the sheriff authority over federal officials and agents within their county, as well as any other government agent or official in their state, as it is the sheriff who has the duty and authority of upholding the Constitution, as well as carrying out the enforcement of our laws and determining if they're constitutional or not. So let's consider that. So many officers, well, it's in the law, I must enforce it. Okay, but is it constitutional? Well, if I don't enforce it, I'll be in trouble. No. In the Washington State Constitution, Article 1, Declaration of Rights, Section 6, there's a protection written in for the people, for elected officials, for appointed officials, and it's called oaths, the mode of administering. Now remember, Article 1 is Declaration of Rights, but it says the mode of administering an oath or affirmation shall be such as may be most consistent with and binding upon the conscience of the person to whom such oath or affirmation may be administered. Because what the writers of that Constitution said is that each person has free will and right of conscience. As a peace officer, I cannot be forced to violate the constitutions or the law, be threatened with my job, losing it, if I know by conscience or right truth that what's being enforced is illegitimate. It's a protection for the sheriffs, for the electeds, for the judges, for the legislature, and for the appointed officials. The problem is, on my side, many peace officers, they swear an oath, but they've never read the documents that they swear an oath to, so they have no concept of what it means. And that is disturbing, because our public schools aren't doing a good job of educating our public in their form of civil government. The federal Constitution, Article 6, Clause 2. This Constitution, because in Article 6, Clause 2, the Constitution itself declares the Constitution the supreme law of the land. And I'll just read those two pieces because there's a couple, if you can see it there in the black, I've highlighted it in blue. In Clause 2, it says, "This Constitution, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding." Clause 3, "The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution." So understand, the peace officers and elected officials, they raise their right hands, but they don't know why. They don't know where to go to cite the information that requires their oath. And what is an oath? It's a bond. It's a pledge. But today they've forgotten that, because it's about liberty, not keeping you safe. There is no safe of God's hand over us in the day in which we prepare for evil. But the sheriff has the sole authority in any county. And I liken this because so many of us in my profession are labeled law enforcement officers. I am not a law enforcement officer. The law is written, I must enforce it. Well, let's remember that everything the Nazis did was legal, did not make it moral or righteous. And that's why we have written constitutions, to make them supreme law so that people can refer back to them and keep them bound and in their limits. So the sheriff's authority, does it conform to the Constitution? When called upon to enforce a law or ordinance, it's important for the sheriff to know if the said law falls within the constraints of the Constitution. Just because a law has been passed by the legislature does not mean that it meets constitutional muster. Just because a law has been passed, does not meet constitutional muster. To an even greater level, if this is true of ordinances, rules, and in particular administrative rules enacted by government bodies and officials inferior to the legislature. Let's talk about the three-letter agencies that have no elected authority, but BLM, the EPA, some of these others, they have no elected authority, but yet they write these rules and regulations over us that much of it does not comport to the Constitution. So remembering where the authority of government emanates from, the Constitution, and ultimately we the people, anything enacted by a person or body that is not directly elected by we the people is inferior to anything passed by the legislature that was properly elected by we the people, or county or city officials that were directly elected by we the people in their own political subdivisions. In making these decisions, in addition to the requirements to uphold the oath of office, there are also Supreme Court decisions, along with lower court decisions and references in American jurisprudence that support determining the validity of a law and the refusal to enforce it based upon its lack of constitutionality. Chief Justice John Marshall, in his opinion in Marbury v. Madison, 1802, said, "The particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument." He's speaking, they are bound by the Constitution. Consider what you've seen in our courthouses today. Those judges do not rule us. Those courthouses and those courtrooms are still open public spaces, and they belong to the people. Although you've got to conduct yourself properly, but many of those judges, even they don't understand their oaths. So let's look back at some previous court cases. Miranda v. Arizona, 1966, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Or Norton v. Shelby County, an unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protection, it creates no office. It is in legal contemplation, as inoperative as though it had never been passed. So understand what the court held in Shelby County and in Miranda, as well as Chief Justice Marshall. And we all know these things. We know it. The problem is government doesn't know it anymore. And then concluding Sumner v. Bueller, all persons are presumed to know the law, and if they act under an unconstitutional enactment of the legislature, they do so at their peril and must take the consequences. So what he's saying is the law in our hearts, the Constitution, it's presumed. And for our legislatures, if they act under an unconstitutional enactment, they do so at their own peril, meaning they can be sued, right, for a violation of your rights. But it's also meant you can give up your rights if you want to, but you do so at your own peril. Never, ever give up your rights. Because in my line of work, there are many, 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 many good officers out there. But again, they are ill-educated into the form of their own civil government and the purpose in which they do their jobs. Yes, it's to find the bad guys, to enforce the laws, to hold them accountable for the violation of others' rights. But they forget that the authority they hold is on loan to them. It is not to be used to lord it over the people. So in American jurisprudence, which is used by the courts and the law profession as their encyclopedia for what is law and what is not law, or what its meaning is, it states, the general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose. Since unconstitutionality dates from the time of its enactment, and not merely from the date of the decision so branding it, an unconstitutional law in legal contemplation is as inoperative as if it had never been passed. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. But understand today, we have become an oligarch. All branches of government are the same. They are not separate and co-equal anymore. And some sheriffs are getting it. They are discussing how to deal with the other three branches of government because they're realizing their authority, meaning the other branches of government cannot do what they want to do if they don't have the enforcers on board with them. And it frustrates the other branches of government. And good on the sheriffs who are awake and understanding that they are to be the high protectors of the people's rights. That's what they're there for, to interpose themselves. In Washington State, RCW 36-28010 are the general duties of the sheriff. The sheriff is the chief executive officer and conservator of the peace of the county in the execution of his or her office, he or she and his or her deputies. And so what this means for me, I have the same authority as the sheriff. I have the same duty as his deputy to uphold my oath to the Constitution, to protect rights, to execute the law, to apprehend evildoers, to incarcerate them. But I must do it properly within the confines and the limitations placed on me by the Constitution. And there's one portion here where it states that the sheriff is a judicial officer. That is true too. We shall execute the process and orders of the courts of justice and judicial officers when delivered for that purpose. But the portion here says, according to law, not the legislative law, the constitutions, because they are supreme law. There are many sheriffs and jurisdictions that enforce civil law in which they deprive people of their rights, in particular regarding ex parte orders and firearm seizures. There is nowhere in those civil orders that comport with probable cause under the Fourth Amendment for the sheriff to act to do that. He violates his oath. The judge violates his oath in doing such things. There is nothing supported in those by probable cause under the Fourth Amendment that a crime had been committed. It is strictly words on paper that they act on. And gratefully, my sheriff has determined for that himself does not do those things. So let's talk about the division of power. We have three co-equal branches of government. The problem is many elected officials don't understand that today. The legislature writes the law. The executive branch enforces it because it's written. And then the courts determine the guilt. And we've all seen a lot of laws that are illegitimate. But the problem today is our government is one big club. They've forgotten that each branch has the same purpose, to protect and maintain individual rights, to uphold their oaths. So there's an excellent case that clearly defines the division between state authority and federal authority in Prince v. U.S. So in 1993, when the Brady Handgun Violence Prevention Act was attached to the Gun Control Act of 1968, which I contend is still illegitimate, the interim part of the bill required handgun purchasers to fill out a form which the gun dealer would then provide to the chief law enforcement officer in the applicant's area. The CREO, which was the sheriff, would then be required to make a reasonable effort to ascertain within 5 days whether receipt or possession would be in violation of the law, including research in whatever state and local record-keeping systems are available in a national system designated by the Attorney General. So Sheriffs J. Prince of Ravalli County, Montana, and Sheriff Richard Mack of Graham County, Arizona, both filed challenges to the constitutionality of the congressional order to compel state officers to enforce federal law. The case was heard by the U.S. Supreme Court, which ruled in favor of the plaintiffs. And in their decision, Justice Antonin Scalia wrote, God rest his soul, "The great innovation of this design was that our citizens would have two political capacities, one state and one federal, each protected from incursion by the other, a legal system unprecedented in form and design, establishing two orders of government, each with its own direct relationship, its own privity, its own set of mutual rights and obligations to the people who sustain it and are governed by it." Because what he said was, the federal government has not the authority to direct state officials to do such things that would violate their oaths of the Constitution or the people's rights. He also quoted President James Madison. "The local or municipal authorities form distinct and independent portions of the supremacy, no more subject within their respective spheres to the general authority, and the general authority is subject to them within its own sphere." And that was James Madison in Federal 39. Scalia also referred to New York v. U.S., where Justice O'Connor wrote, "The states are not compelled to participate in a federal regulatory program," once again reaffirming states' rights under the 10th Amendment, which she stated is the core of state sovereignty. And the court properly ruled that the state legislatures are not subject to the federal government. If the state legislature is not subject to the federal government, then neither are any of the political subdivisions of the state. That includes your counties, your sheriff. This case is similar in nature to when the federal government attempted to implement and enforce a federal prohibition against the possession of firearms within 1,000 feet of any school. Their claim to the authority was under the Interstate Commerce Clause and was found by the Supreme Court to not apply, and was in fact outside their lawful authority of the federal government to impose such restrictions on the states. And that's what we've forgotten today within the division of power between the federal government and the state governments, and then the three branches of government. So let's look at some definitions. Constitutional officer, one whose tenure or term of office are fixed and defined by the Constitution as distinguished from the incumbents of offices created by the legislature, meaning the state determines those. And that comes from Foster v. Jones, 79, 642-52 AMRIP, which means police chiefs, police officers, and state police are not constitutional officers. They are not elected, but they do have to swear an oath. The sheriff in American law is the chief executive and administrative officer of a county, being chosen by popular election. So understand that. Being chosen by the people to be the executor of their laws. His authority comes from you, the people. His principal duties are in aid of the criminal courts and civil courts of record, such as serving process, summoning juries, executing judgments, holding judicial sales, and the like. He is also the chief conservator of the peace within his territorial jurisdiction. Harston v. Langston. Law enforcement officer, those whose duty it is to preserve the peace. That's Frazier v. Elmore, Tennessee. And then the term peace officer. This term, variously defined by statute in the different states, but generally it includes sheriffs and their deputies, constables, marshals, members of the police force of cities, and other officers whose duty it is to enforce and preserve public peace. So these are all definitions that have been defined by the courts as to who is what, who has the supreme authority over whom, and it still lies with the sheriffs because of our form of civil government. So now I want to talk about threats to the Constitution, state sovereignty, and the office of the sheriff. So there has been recent legislation at the federal level from the present administration that most Americans don't know about. They don't read about it. You know, there are some news outlets out there who speak about it, but by and large, most Americans just like to go on their way. And like frogs being boiled in water, it usually doesn't end well. So there are a number of actions and legislation that are a threat to our constitutional rights and state sovereignty and the means to usurp the authority of the sheriff. And it's important to understand what these are and their implications. Some of the most far-reaching are FEMA, executive orders, declared national emergencies, czars, and the John Warner National Defense Act. You know, here's a government thinks that they have the power to declare martial law. Well, they don't. It's like Ayn Rand says, government only has the power to crack down on criminals, and that's true. But they can't just go, you know, there's lots of bad things happening and we've declared emergencies, so none of you people have any rights until we tell you and the emergency's passed and we give them back. That is not accurate, which means any of their acts become illegitimate under these two constitutions, meaning your state or the federal constitution. So understanding the authority of the office of the sheriff and the constitutional limitations of both Congress and the president, it's important to review the U.S. Senate report 93-5459 and its relation to FEMA and executive orders. And this is kind of extraneous. But in the report, it's entitled Emergency Powers and Statutes, Provisions of Federal Law Now in Effect, Delegating to the Executive Extraordinary Authority in Time of National Emergency. And it's dated November 19th, 1973. But with reference to a national emergency, it's important to understand that this nation has been under one or more declared national emergencies continuously since the first one declared by President Franklin Roosevelt in 1933. And most of the declared national emergencies have not been allowed to expire, but continue to be renewed by sitting presidents. And so the following portion is an introduction to the Senate report that I cited, 93-5459, written by co-chairmen Charles McMathias Jr. and Frank Church. In their report, they cited, since March 1933, the U.S. has been in a state of declared national emergency. In fact, there are now in effect 4 presidentially proclaimed states of national emergency. And let me point out that, for those, well, this sounds a little conspiratorial. This is right from a Senate report from 2 elected senators. So let that sink in. This isn't just somebody out there cranking the siren. But they state, in addition to the national emergency declared by President Roosevelt in 1933, there are also national emergency proclaimed by President Truman in 1950 during the Korean conflict, and the states of national emergency declared by President Nixon in 1970 and 71. So these proclamations give force to 470 provisions of federal law. These hundreds of statutes delegate to the president extraordinary powers, ordinarily exercised by the Congress, which affect the lives of American citizens in a host of all-encompassing manners. And the vast range of powers taken together confer enough authority to rule the country without reference to normal constitutional processes. So understand that. This isn't East Germany. This isn't some third world nation. But we've enacted laws that are in place that could be acted upon given any emergency they deem. This concerns me greatly as a peace officer and a veteran. So under the powers delegated by these statutes, the president may, and it's right in the report, seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communications, regulate the operation of private enterprise, restrict travel, and, in a plethora of other ways, control the lives of all Americans. And I don't know myself, I have great difficulty and compunction with that. I hope you do too. And this is why Americans need to be educated in their own form of civil government regarding natural law, the Constitution, individual rights. Dig in and delve into the history of the forming of your nation and your government. Read John Locke, The Rights of Man. But Americans need to realize no government or its officials have the authority or right to nullify the Constitution and its individual protections, or nullify or abrogate an individual's natural and common law rights. Government cannot, in time of emergency, say, it's an emergency, so we've ruled you have no rights till we say the emergency is over. That's tyranny, that's despotism, it's dictatorship. No one and no government can remove inherent rights. It only has the power over criminals, and it cannot make up laws to make criminals in order to take rights and property. You know, the oath to the Constitution must be maintained and upheld by all elected officials. Following orders, obeying a law or order that contradicts the Constitution makes one lawless and in rebellion to the supreme law of the land, and therefore a criminal. Right? If I violate or government violates a person's rights, that means they do so without the legitimate authority of law. It makes them a criminal committing a crime against a citizen without legitimate authority, because the Constitution doesn't allow those things. The Bill of Rights doesn't allow it. I was just following orders, or I was just following the law won't cut it, right? In German, Befehl ist Befehl, meaning orders are orders. The Nuremberg defense doesn't fly. And it won't work, and it didn't work at the war crimes trials any more than it works for anyone who violates God's supreme laws, which are enshrined in the Constitution and the Bill of Rights. The oath one takes states, I, Nathan D. Hockett, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely and without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter, and I will obey the lawful orders of those appointed over. So help me God. That's my Marine Corps oath. But an oath to the Constitution means an oath to the people to protect their rights, their property, their free speech, their firearms, all these things. Other threats to the Constitution and the office of the sheriff are FEMA. FEMA was not created by Congress, but by Jimmy Carter by means of executive orders. Specifically, FEMA was established under the 1978 reorganization plan and activated in 1979 by Jimmy Carter under an executive order. He then signed that order, moving disaster relief under the control of FEMA in 1979. A review of the constitutional limitations of the president show this to be contrary to constitutional law. Even if passed by Congress, it does not fall within the scope and authority of Congress in regards to the individual states and is violation of the 10th Amendment. If it is for the sole purpose of providing aid in time of disaster or emergency, that could be provided, but there is no lawful basis for FEMA to have any lawful control over the individual states. Executive orders. Those are the arbitrary and capricious will of men, unless they understand their limitations of power. Granted, the president has authority and a duty to protect the United States, but from without. So it's important in understanding the relationship between the office of the sheriff and the effect of presidential executive orders. The information and background for executive orders is best defined in Executive Orders in Times of War and National Emergency, a report of the Special Committee on National Emergencies and Designated Emergency Powers, United States Senate, 1974, and it's Library of Congress. So there are two pertinent portions. One, in general, from 1789, presidents have issued orders and directives which in general terms may be termed and described as executive orders. These orders in the early years of the Republic differed extensively as to form and substance from what we know as an executive order today. Essentially, an executive order is a written document issued by the president and titled as such by him or at his direction. The subject matter of each executive order may be ascertained from the examination of the order itself. The executive order in the last 50 years has become a governmental instrument of broad and increasing importance, a fact which has been made particularly obvious since 1933. So, executive orders may be repealed or modified by the president issuing them or a following president, even if many years have passed. Executive orders may be repealed or modified by Congress or by a decision of the judiciary. Some executive orders become obsolete by the passage of time, as when it bears an expiration date or when the purpose for which it was issued no longer exists. Otherwise, an executive order, once issued, remains in effect until repealed or modified or expires. There is no law or even an executive order which attempts to define the term executive order. In the narrower sense, executive orders are written documents as such. Generally, executive orders are directed to and govern actions by government officials and agencies, right? They usually affect private individuals only indirectly. So the authorities cited in executive orders, I'm gonna start using the term EO. Virtually all EOs cite some authority upon which they are issued. Some rely exclusively upon the general powers of the president. Some cite specific federal statutes, while a few of the are transitory and non-controversial nature, fail to cite any authority. An example of orders which have not cited any authority is Executive Order 10671 dated June 1956, which directs that U.S. flags be flown at half-mast in honor of the late Admiral Ernest J. King. I'll have to research him, but, you know, it was to honor him, but there's no legislative authority behind the allowance of an executive order. But a very large number of EOs cite only broad grants of authority, such as by virtue of the authority vested in me by the Constitution and the laws of the United States, and as President of the United States. Some orders simply state by virtue of the authority vested in me as President of the United States. And these appear to be used when there is no express statutory authority, or when express authority may exist, but it is desired to use as a catch-all expression. In a few cases, the Charter of the United States has been given as authority. Executive Order 10422 is an example. It was used by President Truman in 1953 to prescribe procedures for making available to the Secretary General of the UN certain information concerning U.S. citizens employed or being considered for employment on the Secretariat of the United States, or excuse me, of the United Nations. So, you know, there is no written statutory authority that allows a president to say, you know, we're just going to let all these people in. Because I said. But many executive orders cite both general powers and specific statutory authority as authority for their issuance. But there is no provision in the Constitution for executive orders, and without lawful constitutional standing, they lack subject matter and statutorial jurisdiction. And this is especially important to understand with respect to Executive Order 12425 and the amended version of 13524. And this section, as far as threats to the Constitution, state sovereignty, and the office of the sheriff, this is geared towards the sheriffs because they need to understand that executive orders usurp their authority. The federal government has not the power to do that. Although they think they do, some will cite the Supremacy Clause. But in 2009, President Obama signed that executive order, and it amended President Reagan's executive order dated June 1983. And here's what Reagan wrote. Amending executive order designating Interpol as a public international organization entitled to enjoy certain privileges, exemptions, and immunities. Reagan wrote, by the authority vested in me by President, or as President, by the Constitution and the laws of the United States of America, including Section 1 of the International Organization Immunities Act, and it's cited, it's a United States code, in order to extend the appropriate privileges, exemptions, and immunities to the International Criminal Police Organization, Interpol, It is hereby ordered that executive order anyway, dated 1983 as amended is further amended by deleting from the first sentence the words except those provided by section 2, section 3, section 4, section, and the semicolon that immediately precedes them. So the current president amended Reagan's act. And that makes a big difference because what it allowed Interpol to do is to have pretty much carte blanche movement in the United States. So the original executive order signed by Reagan in '83 was for the purpose of limiting the diplomatic privileges within the U.S. granted to Interpol and under the International Organizations Immunity Act, because nations, they work together to fight criminal activity crossing their sovereign bounds. It did not grant Interpol the privileges included in those sections, giving them diplomatic style immunity. Giving immunity to international organizations or agents and records from search, arrest, or confiscation. But specifically in Section 2, it was included in the exemption clause so that the United States government could maintain oversight concerning Interpol's operations within the U.S. Presently, President Obama has removed the exemption clause. Interpol now has vast jurisdiction within the U.S. with no oversight, and the immunity clause now applies to Interpol within the U.S. And anybody who understands the diplomatic community or has seen news stories or anything in the past, if you have diplomatic status, you are immune from prosecution. You're immune from being held accountable. So if a diplomat comes here and commits a crime, he gets to walk. The problem is when you start allowing international enforcement agencies that same authority, their acts, any acts they commit, are protected. They also get to walk. So this is quite wordy. It's, legislative verbiage. But the point is the sheriffs have to understand where they stand and what their purpose is. And that again is to protect the people. One day I am going to retire, as well as the sheriffs and other elected officials, and they forget that their authority comes from the people. It's on loan to them. I'm going to remove this and say thank you, ladies and gentlemen, for loaning me your authority these 30-some years. I hope I've been good and just in the righteous execution of your laws. There's a more recent executive order from January 2010. Under the section executive order, under section 4, the term state means any state of the United States, the District of Columbia, Commonwealth, Puerto Rico, Virgin Islands, Guam, American Samoa, Marianas. But the term governor listed in there means the chief executive of any state. So at this writing, the executive order has not been published in the Federal Register yet, and that was, of course, this is Stephen's work when he wrote this. But it currently does not show a number designation, but only a date of issuance. So the order is there. It's ready to be issued. But it establishes what they call the establishment of the Council of Governors. So it writes, by the authority vested in me as president, by the Constitution and the laws of the United States, including Section 1822 of the National Defense Authorization Act of 2008, which is a scary piece of legislation, in order to strengthen further the partnership between the federal government and state governments to protect our nations and its people and property, it is hereby ordered as follows. Section 1, Council of Governors. There is established a Council of Governors, hereby known as the Council. The Council shall consist of 10 state governors appointed by the President. members of whom no more than 5 shall be of the same political party. So they divided them up, 5 Republican, 5 Democrat. The term of service for each member appointed to serve on the council shall be 2 years, but may be reappointed for additional terms. The president shall designate 2 members who shall not be members of the same political party to serve as co-chairs of the council. And then their functions. The council shall meet at the call of the Secretary of Defense. The council shall meet at the call of the Secretary of Defense? Or the council or the co-council to exchange views, information, or advice with the Secretary of Defense, the Secretary of Homeland Security, and the Assistant to the President of Homeland Security and Counterterrorism, the Assistant to the President for Intergovernmental Affairs. So it lists all the people they're going to meet with, but it also states such views, information, or advice shall concern matters involving the National Guard of the various states, Homeland Defense, civil support, synchronization and integration of state and federal military activities in the United States, other matters of mutual interest pertaining to National Guard, Homeland Defense, and civil support activities. So understanding the governors are being drawn into federal authority. They're discussing with the Secretary of Defense issues regarding the states, synchronization and integration of state and federal military activities in the United States. For those of you who are veterans and or long-term career veterans, that should be concerning, particularly with the study of history. What this does is it begins to create a council and gives them authority, these governors, over the people. It subordinates the states to a 10-member council. So consider this subsection E in the administration. The council may establish a charter that is consistent with the terms of this order to refine further its purpose, scope, and objectives, allocate duties as appropriate among members. So this is totally counter-constitutional. These are 10 governors coordinating with various federal agencies to make decisions rather than leaving it to the state legislatures themselves for whatever purpose or future event they're planning for. But in the end of it, there it is. This order is not intended to and does not create any right, benefit, substantive or procedural, enforceable, outlaw, or inequity by any party against the United States. Its departments, agencies, or entities, its officers, employees, or agents, or any other person. Barack Obama, White House, January 11, 2010. So this order has not been executed. It has not been placed on the Federal Register. But it should be concerning as a threat to state sovereignty in the office of the sheriff. But reading through this, the President shall establish a bipartisan council of governors to advise the Secretary of Defense, the Secretary of Homeland Security, and the White House Homeland Security Council on matters related to the National Guard and civil support missions. So when you read carefully sections 2 and 3, in section 2, it first places a group of state governors under the direction of the Secretary of Defense. In section 3, it provides for the group to write its own charter rather than that be written by Congress, and through establishing subcommittees, expand the organization with designated employees on which there is no limit. And this is yet another blatant federal incursion into and over state governments. The fact that governors include the chief executive of any state as defined in this executive order puts the true states on the same par as the United States of America protectorates, such as the Virgin Islands, Guam, etc. This puts the states in a subservient role to the federal government. Now, in the John Warner National Defense Authorization Act, Section 1076, which was signed into law October 6 by President Bush, this law virtually guts the Posse Comitatus Act of June 18, 1878, found at 18 U.S.C. Section 1835, which prohibits the military from performing law enforcement duties within the borders of the United States. Read it carefully. It allows the president at his discretion to implement the military to enforce laws and restore public order if he believes that the state or local officials are incapable of doing that. This is a clear violation of the Constitution, and when read closely, reveals an open-ended means to allow the president at his discretion, without congressional approval, to use the military to take over a state. And it doesn't matter whether it be present administration or a future administration. This creates a problem for the states. When you read Section 1076, it says the use of armed forces in major public emergencies. Use of the armed forces in major public emergencies. The president may employ the armed forces, including the National Guard and the federal service, to restore public order, enforce the laws of the United States when, as a result of a natural disaster, epidemic, or other serious public health emergency, terrorist attack or incident, or other condition in any state or possession of the United States, that the president determines. So these are all available. But understand what this does. It usurps the authority of the sheriff. It guts states' rights. National emergencies. So looking at this in conjunction with the limitations of the office of the president and that of Congress, it's important to understand that the use of natural emergencies and their application, as stated in the Senate report, the subject of declared national emergencies is addressed in the United States Code in Title 50, Chapter 34. In the past, any time a president declared a national emergency, it continued in effect as long as it did not have a specific expiration time, or it was renewed regularly, which is what has happened since 1933. Eventually, Congress put stipulations into the code regarding the expiration of declared national emergencies because they began to realize and see that open-ended emergencies, where the president has authority solely, it puts him in the place, to be a despot, a tyrant, a dictator. So, Chapter 50, Title 50, U.S. Code, Chapter 34, Subchapter, blah. Termination of existing declared emergencies. All powers and authorities possessed by the President or any other officer or employee of the federal government or any existing agency as defined in Section 105 are terminated 2 years from September 14, 1976. Such termination shall not affect any action taken or proceeding pending not finally concluded or determined on such date. And this is getting wordy, but the fact is these are all threats to our liberty. They're threats to the states. They're threats to the Constitution. They are threats to the office of the sheriff, who again is the highest peace officer, the highest conservator, and the high protector of the people's rights under the oath that they swore. Many of the Western state sheriffs they're waking up, they're standing up, and they're standing together, and it frustrates the powers back in D.C. They talk of czars. There's no constitutional provision for czars. The president is elected by the Electoral College. They're just administrators. They don't get to make law regulation that affect the constitutional protections and property of American citizens. Czars are rulers of Russia up until the Communist Revolution in 1917. I don't need a ruler, neither do you. So there are many things in place right now with Obama's planned civilian national security force. From his own quote in July 2008 in Colorado Springs, "We cannot continue to rely on our military in order to achieve the national security objectives that we've set forth," whatever that means. "We've got to have a civilian national security force." Well, I know someone else in history that had another civilian national security force. Could it have been and I hate to say it this way, but let's just say back in the 1930s, a certain man named Hitler had the Schutzstaffel and the Schutzabteilung. The Constitution provides for security forces, which is the military. It provides for the executive branch to enforce the law as our peace officers. But there are many more things being put in place, and we all know it, we all feel it. And it's just a matter of having the knowledge of it and being able to step up to your elected officials and educate them properly. But many don't really want to hear much of it anymore. They're almost at arm's length from us, the people. The U.S. Army produced, through the RAND Corporation, which they write a lot of white papers, policy papers, wrote a report entitled "A Stability Police Force for the United States, Justification and Options for Creating U.S. Capabilities." And as a peace officer, there are white papers, and as a former military officer, documents written in which the federal government will offer military assistance to civilian authorities. But once they relinquish their authority, the military does not give it back. It's theirs until the conclusion of said emergency or whatever event that's occurring. So, our sheriffs need to be aware of these things. This is not stuff that's out there. This is actually written orders, written white papers. They are fact and they are there. So I'm going to conclude here. And, it was intended for this presentation to be half the length that it is. The problem in doing that was the continual discovery of more and more usurpations of our Constitution and increased federal incursion upon the states, especially through the issuance of unconstitutional EOs. And to stop the violations of our constitutional rights, we need to be educated as to what is taking place, which requires vigilance in researching what the federal government is doing, especially with regards to acts buried deep in legislation and executive orders. And I'll leave you with this quote from Thomas Jefferson, because he gave us a warning when he said, "If a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. The functionaries of every government have the propensities to command at will the liberty and property of their constituents. There is no safe deposit for these but with the people themselves, nor can they be safe with them without information. Where the press is free and every man is able to read, all is safe." And that was a letter to Charles Yancey in 1816. So, in order for the sheriff to be effective in upholding and defending the Constitution along with the people's rights, they must be knowledgeable in it, and in their lawful authority and supremacy to usurping acts. To be successful in this, the public must also be knowledgeable so that they will be supportive of the sheriff. And with this, great things can be accomplished. And while it's not easy, it can and must be done, and is the responsibility of the sheriff to do so. The education of the public at large was addressed by Edmund Burke when he said, "If this young republic ever goes down to oblivion, it will be because of the difficulty of educating its multitudes of rulers." So I'm going to conclude here, folks. It's much better for me to actually do this in front of people. So I thank you for your time and your candor. And I guess we'll be open for questions. Pam.
Okay, so the first one is from Rob Chase. He says, since a county treasurer is an elected constitutional office, then I am a co-equal to the sheriff, at least pertaining to my duties, ?
That is correct. One branch rules not over the other. It's like I've shared with my sheriff. The governor cannot come down to his political subdivision and tell him how to run it. Just as as stated in the presentation, even the courts have said the subdivisions are their own authority. Do you have to follow state law? Yes. However, you swore an oath. Your job as the treasurer is to be a good steward of the public's money, correct? So the sheriff doesn't run you. You don't run the sheriff. You just hold the purse strings. You administrate it.
So Jeff Broadhead makes a point about, he states, government seems to love contracting authority to persons, individual corporations, associations, not bound by oath, as a way of circumventing the constitutions. And then he says, in quotes, plausible deniability. And I would add, my brother is in the military, and he comments about that, to where more and more they are outsourcing jobs, kind of everything, to civilian contractors. And this does seem to be kind of an epidemic. Do you want to comment on that, Nate?
Well, when you mean civilian contractors, you mean like the types of contractors that were in Iraq, or those that are going to provide services for plumbing and building and such? Now,
in terms of Iraq.
Okay. So that would be what they call in their duties under Article 1, Section 8, to give a letter of marque, right? Meaning they can hire mercenaries. Under Article 1, Section 8, sorry, the clause evades me, I can go back to it, but where they give letters of marque and reprisal. They can do that, but it was to be against our enemies. Not internally, but against the enemies of America. Now, they can contract privately with private business to do work. That seems reasonable. Meaning contracting for building, roads, plumbing, other services.
So, comment on the Bundy Ranch situation. So you have the sheriff who enforced dual jurisdiction and made the feds move, and we kind of talk about it in terms of the feds' jurisdiction was the cows, the sheriff, his jurisdiction was to restore the peace trumped cows, feds left. Would you kind of have a similar analysis, or what's your observations on that?
Are you talking about the Nevada event 2 years ago? That Bundy event?
Yes. Yes.
Well, I think it was a multi-pronged event. A lot of the rural sheriffs in the western states they're not educated to understand that their lands have not been disposed of properly as per law and the Constitution. The feds still hold them in trust, yet they hold title. The sheriffs and the states hold jurisdiction. I think what turned that was, and I don't pay particular attention to the sheriff down there, whether he stepped up or not, because you got to remember, a lot of these rural counties receive a lot of federal funding. And what happens with federal funding and grants, they come with the chains of slavery. They come with provisions and requirements, which equates to money within those jurisdictions. But I think the biggest thing that turned it down there was American citizens standing up for their rights. Thank God there was no bloodshed or violence. That is not something either side wanted, and it should be avoided at all costs. But I think between negotiations with various entities there, legislatures that came down from the various states, even from Washington and other states, helping to intermediate that, made a big difference. But I think, if most sheriffs understood that authority, they would have put a stop to it immediately. But like I said, many don't. They're ill-educated. They come from, the ranks of being a deputy. And a lot of elected officials seem afraid to touch the Constitution like it's the third rail. I see, if we educate them, as a young deputy in the 90s, the Clinton administration came out with a small handbook called the Prosecutors and Law Enforcement Handbook on Extremist Groups in America. But within that book, it named American citizens that would assert the Constitution, that would define the description of a republic, which is individual rights. We're not a democracy. It's stated as such in Article 4, Section 4, and that the United States is to guarantee to every state a republican form of government, little r, not party. And what it meant is that in a republican form of government, the individual rights of the person are greater than those of the collective will of the people, or the usurpating authority of the government. So maybe in a roundabout way, I think between government officials being involved, citizens stepping up and coming to the aid of their fellow citizens, there was a show of arms, but there was not a use of force. And I think that was probably one of the issues that, the agencies, the federal agencies down there took into consideration. They didn't want to, cross that Rubicon, to where force would have been used on either side. I think they knew it would have ended poorly, and it would have made them look more tyrannical than what they were.
Okay, Jason and Tabitha have a question. How are we to enforce these truths should we find ourselves in an unjust or court situation? Example, Lavoie and now the Bundys.
Wow. Well, I look back at history where our founders, when they wrote in the Declaration, considering courts, not having fair trials and other things, you enforce these truths. One, I would never expect any layman to go into court of their own accord. You should seek counsel, find a constitutional attorney, because they are going to do the research and the legwork, and a lot of judges are ill-educated too, but many of them, there are many good ones out there too. But as far as the federal level, they're appointees, and they're appointed for life. So they're beholding someone. You stand on the truth. You stand on, our Constitution is written from biblical principles. You stand on those principles, and then you bring in the Constitution, which is the supreme law of the land. You expose the illegitimacy of any present law that is being used against you. And hopefully, an informed jury. I recommend the handbook for citizens because it's got juries, a section on juries in there. Juries forget they are of the people. That's their courtroom, not the judges. It's a public forum used in determining whether a person, is innocent or guilty based on the facts presented. But the facts presented are usually from the prosecution, and hopefully they're presenting facts and not embellishing or trying to steer a case so that the outcome is to their liking. But you've got to stand on the law. You've got to stand on truth, which means bringing history forward. You cannot argue with the written facts of what our founders wrote and what they intended. It's all right there. Many of it I cited in this PowerPoint brief. And this is what the sheriffs have to understand. We're a nation where we were meant to have individual liberty. We cannot be licentious. We don't get to do anything we want. We are all persons under authority, God's authority. And even if you're not a person of faith, then that's your natural right, but you still have to live within the confines of the civil society. You cannot be licentious. So,
Hey.
Go ahead, Pam, next question.
Okay, sorry. I think we're going to go ahead and wrap things up. We're almost at 8 o'clock. Jason and Tabitha say thank you. We are going to, just so everyone knows, in case you weren't following the chat, it is being recorded and everyone will get a copy of this. It'll be a video recording, so everyone can go back and go through the PowerPoint. We did have someone who wanted to know if the students could get, and our guests could get the PowerPoint.
I'll tell you what, at this point, because it is geared for the sheriffs and being a peace officer myself, I kind of prefer to hold that close, but I would be more than happy to, they can have a copy of Stephen Riley's written compilation. You know what? Go ahead and let's get it to them, Pam. Let's get it to them. They can, it needs to be disseminated. Yeah,
Are you sure?
I think so. If somebody asks me to present later, their elected officials need to see it too. So, I'm kind of hoping to be invited to speak at some of the sheriff's conferences, but that's still up in the air. But our sheriffs more and more, especially in the western states, are waking up, and they're beginning to understand where they're set, And it's just a matter of educating them, educating our fellow citizens.
So can I include your contact information?
Certainly.
With the email.
Now the PowerPoint is too large to email. I would more than likely have to put it on a disk and send it that way. If they're willing to pay postage, I'm willing to do up the discs. How's that?
We could actually, I could actually put it in CSG's
Okay.
Dropbox, and we can send out
All
the
right.
link
Yeah. Excellent.
to all of the
Excellent.
attendees,
Good.
and we can do it that way. Awesome. Okay, well, thank you everyone for attending. I'll probably get everything out to all of you tomorrow. Probably won't get it done tonight, but we appreciate your donation to CSG. We appreciate your time tonight. Thank you so much, Nate. It was a great presentation as always, and we look forward to educating our sheriffs and other elected officials.
Okay, well, I feel like I kind of went on, but like I said, it's a lot different when you're just doing audio than presenting in front of an audience.
good stuff. Everyone's saying, giving you rave reviews in the chat box. So, okay. Thank you, everybody.
All right.
Have a good night.
So once I conclude this, I'll be disconnected off of any audio video, Pam. All right, dear.
Yes, all you have
I
to
guess
do is
I'm hopping
close
off here. God bless everyone.
Okay.